Thank you, Mr. Chief.
Good speech.
Going to call Marima Davidson.
Mr. Chair. Thank you, Mr. Chair. What do you know? Still opposing this housing legislation amendment. So what we're talking about in this committee stage of the House is part 2. Now, I've just been talking to my colleague Maureen Pugh to confirm that her and I are the newest members in this House at this moment. And for some of the longer serving members, it might become less than obvious that, as my colleague pointed out, the way that we talk about the processes in here is not always accessible to all of the public. And I think it's really important, as sexy as Parliament TV is, that we ensure that the processes are clear. We're still coming to grips. I'm sorry, I won't speak for my colleague. I'm still coming to grips with this process. So this bill and part 2 that we're talking about right now is being rushed under urgency in the House, being rushed to be passed. And what this means, so from 3 p.m. yesterday, we've been here rushing through all of the stages of passing legislation that will apply to our New Zealanders through the House. And this is not ordinary. So we're rushing through. So this means that there is no longer the time between the readings to ascertain what is in this legislation, to hear from officials and experts in the area, to deliberate across the parties about this bill, to go into what we call the select committee, to sit down and pull this legislation apart, deliberate about it, and hear from the public, hear the public submissions about this bill. And that is necessary in a democratic society so that we can make the best legislation, hear all the things, and make sure that we are protecting New Zealanders' rights. And so this is being rushed through urgency to wipe out all of that process. So it absolutely denies us the opportunity to really suss out how this legislation is going to impact on people, on all the different groups of society. Further to that, there is ordinarily another report that is done by the government departments that they sit down and they really go through and have a look and prepare a report for all of us members of the House. Now, for part 2, the very part that we are discussing right now, this was not completed. This is how rushed this legislation process is for this particular bill. So we're really sort of not upholding the best democratic process with this particular piece of legislation, because there are times when legislation does need to be rushed through the House. But this is important for this part 2. This is of deep concern to the Green Party, this part of the Act that is being rushed through the House, because it pertains especially, it is about the offer-back provision, which I will explain. But this bill wipes out, destroys the offer-back responsibility that the Crown has to public landowners, to the public, when they are landowners or descendants of land that was owned in their whakapapa in their whānau. So just very quickly, the offer-back is when the land was taken from or gifted by any owner under the Public Works Act, and when the Crown no longer needs that land anymore. They have to, ordinarily, they would have to offer back that land to the previous owner or their descendants. If the previous owners or descendants don't want it, by the way, and the offer back, it has to be offered back at the market price or below. If they don't want it, then it can be sold. Then, only then, can it be sold on the open market. So part 2 of this very bill that we are discussing destroys that obligation of the government. And that is why the very fact that we are rushing this through urgency, and the very fact that there was no departmental report into the impacts of this part of the legislation, this is a thing, this is a big thing. I want to quickly acknowledge what my colleague Kelvin Davis was referring to, which is the right of first refusal under Te Reti o Waitangi settlements, because part 2 also contains a protection, a so-called protection to the right of first refusal, which is when iwi must be offered first before anyone else, the whenua. However, what my colleague Catherine Delahanty raised in Select Committee today is that it is not a true right of first refusal. It's a right of second refusal in practical terms in some of the treaty bills that are being put through the House. This bill doesn't strengthen... Mr Chair. Thank you, Mr Chair. Thank you very much. So again, part 2 of this legislation also doesn't uphold the absolute right of absolute first refusal. So I wanted to acknowledge that as well. So this has huge consequences, part 2 of this bill. Now, I want to pick up on where a number of colleagues, Grant Robertson, my colleague Metita Tude, Dennis O'Rourke, have asked the question, why? Why this part 2, the offer-back, the destruction of the offer-back provision? Why has that happened under urgency? Such an important and huge consequence to landowners, to the public. Why is that? Why are we rushing this through urgency? Now, I want to refer to the Green Party officially on the 28th of June this year. The Green Party officially asking the minister concerned, because we knew that the state housing law was going to wrap up. It was about to wrap up. So we officially asked the minister what were his plans. This was June 28. What were his plans after the expiry of this legislation, which establishes special housing accords, special housing areas? What are your plans, Minister, after this expires? His reply, his official reply, so this is June 28, was that he hadn't received any official advice or correspondence, okay, June 28. Then, just over a month later, 10th of August, he took this bill to Cabinet. So, either he and his officials rushed this bill up in less than a month, or the minister did not tell us the full story. So we have a right to ask, what is the full story? What is actually going on? If in fact you rushed a bill of this consequence, if you rushed it up in a month, there's no skills there. That is not good governance. That's not good governance. Absolutely, mistakes will be made, as my colleague has just said. Mistakes will be made. That is not good governance. There is a reason why we have good governance processes, particularly when the consequences are huge. So I have just outlined that the Green Party officially asked the minister what his plans were going to be. Month later, he said nothing. Month later, oh, we have this huge bill. Hey, skills, no skills. Okay, so there's some very serious questions that we should be asking here, and I'm thankful for taking this call, because this is the thing. It goes to both how we want to uphold our responsibilities as representatives and good governance, as well as the actual content and how it will impact in the future on landowners, on the New Zealand public. So there's a couple of things going on there, and the minister surely can tell us what the full story is. We are asking what happened, why the rush, or were we not given the full story when we officially asked for advice from the minister and his officials? Thank you, Mr. Chair.
I'm just going to just one moment. I'm going to comment on Chris Hipkins' application for leave, and I have sought advice. So the committee can't give leave for what is proposed, and I want you to explain to me in a minute what your intention is. Only the House can do that. So the process would be that at 12:55, the minister and I would call to report progress. We'd go back into the House. Leave could then be sought, and it's up to members to decide whether they'd accept the leave. So that's the process. So my questions are, by leave, are you seeking that there would be question time, and then we would resume urgency for the remaining stages in committee, followed by the third reading, and then resume government orders of the day as per the order paper, which would be published at that time? Is that what your intention is?
Yeah, Mr. Chairman, when I put the leave, my expectation is that we would simply continue all the way through the urgency and then begin the regular sitting session whenever that may be. However, I understand that there are issues around ministerial availability, for example, for question time at 2 o'clock, and therefore if the course of action that you have suggested is acceptable to the government, it is certainly one that we would support, which is that we would have a question time at 2 o'clock, then move back to complete the urgency motion for however long that is required, and then we would move on to government orders of the day as listed on the order paper, and we would be very comfortable with that course of action.
So to the government, I'm not asking for an answer, but does that explain what the rationale is? Do other parties feel? Do other parties understand what is being mooted here? Yep. And are the New Zealand First party happy? You understand, yeah. So if it's the government's intent, knowing now what you're intending to do, if the government wishes to proceed with that, at 5 to 1, we will need to report progress, and then the House, you would then seek leave, and the House would then decide whether to proceed with what you've suggested. All right, are we all clear on that? Okay. So I'm going to call Andrew Little.
Thank you, Mr. Chairman. I think